Intellectual property. What is intellectual property? A work or invention that is the result of creativity, such as manuscript or a design to which one has rights and for which one may apply for a patent, copyright, trademark, etc. History of intellectual property. Intellectual property have been around since 500 BCE. Many countries have established intellectual property laws to promote creativity and to allow creators to reap all the benefits of their creations. As time has passed, intellectual property laws sometimes differ and have become more complex depending on the country and its laws. But the goal has always remained the same, and is to give the rights for all the creative works that creators make. So why is intellectual property so important? Let's go ahead and give you this scenario where Bob here just finished his superphone. The main features of the superphone is unlimited battery, teleport capabilities, ability to call in an airplane mode, hologram only phone, meaning that the phone is all hologram. And now Bob is not really interested in releasing this superphone to the public for X reasons. Then Bob gets his superphone stolen at a movie theater. Now, why is it so important in this specific case? Because the phone got stolen and sold to company XY, who were completely astonished by the phone. Company XY decided to release the phone to the public since there is no patent or it has ever been registered. And their goal is to make money out of someone else's invention. And that's unfortunate for Bob because he did not register a patent on his phone. Well, Bob will never be compensated for his hard work, and unfortunately, he will never see justice. Now, the greatest tool for any inventor is intellectual property laws that protect inventors from scenarios such as what happened to Bob in this case. And there are many forms of intellectual property. There's patents, copyrights, industrial design rights, plant variety, trademarks, trade dress, trade secrets. Let's go ahead and speak about trade secret first. Trade secret is used to protect different kinds of formulas, configuration, ingredients that need to be remained a secret due to its competitor or imitators. Some famous products that have been protected by trade secret is Coca-Cola, WD-40, and Listerine. One of the pros for trade secret is inexpensive to get, is very valuable, and it does not need to be renewed. Now, one of the cons is that trade secret is only valuable if what's being protected remains a secret. And also, companies need to manage their policy if they're to tell their employees about the secret ingredient or whichever secret that they're being protected by trade secrets. Keeping ingredients a secret requires a lot of money to keep those things secret, as Coca-Cola have their own vault and they have a bunch of security they had to invest in order to keep their secret from getting stolen. As well, if a secret is compromised, then though it remains under protection, it's no longer a secret. Therefore, it could actually become a patent in that case. Now, trade dress. Trade dress is how a product is designed to showcase. Trade dress help customers distinguish original products. The pros of trade dress is that it helps determine if a product is an imitation. It is very difficult to obtain trademarks. Trademarks identifies and distinguishes the source of a service rather than goods. Trademarks typically protects brand names and logos used on goods and services. Trademarks. The pros of trademarks is that it protects your company's name to whichever copy, because there are brand securing in social media, which protects you against abuse, and the renewal process is fairly easy. It is a tedious challenge to start a trademark, as you have to deal with a lot of government agencies. Paying for an application can range from $100 to $400 or more. Renewing trademarks can cost up to $400 every 10 years. Industrial designs rights necessary to protect a manufactured product if its design is available. Visual design of an object, shape, configuration, composition, patterns, colors. Some of the pros of industrial design is that rights are up to 25 years. Some of the cons is that because there are many designs that have been already registered, it's difficult to get a design approved. Copyright, exclusive rights given to an author, a creator, is the most known form of intellectual property and that one that people tend to violate the most. Books, movies, music, artistic works. Some of the pros of copyrights is that a creator is granted a copyright over a work automatically at the time he creates it without registering the product for a period of time, but the protection is limited and immediate action is taken if someone violates your copyright. Now, some of the cons of copyright is that registering your work is time consuming and registering work requires fees from $30 to $200. And enforcing copyright work can be a lot of work as the owners have to be the ones enforcing it. Therefore, they have to invest a lot and sometimes bad guys always get away. Patent. A patent is a set of exclusive rights granted by a sovereign state or intergovernmental organization to an inventor or an assignee for a limited period of time in exchange for detailed public disclosure of an invention. An invention is a solution to a specific technological problem and is a product or a process. Some of the pros of patent is that patenting an idea, a design, or a product can assist the business in limiting competition. The exclusivity that accompanies patent products and ideas provide the patent holder with opportunities to increase profit. A patent can promote further discovery by an inventor and increase the value over time. Patent rights can be sold or licensed for royalties to a third party at the creator's discretion, allowing a company to expand into other regions or markets. The creator can also charge more for the product because they have control over the market. You can justify investing more funds into a product design or product production because no one can copy it without infringing on your patent. Some of the cons of patent is, in addition to prior research, that process of applying for and receiving a patent can be complex and take years, during which you go through several stages of review and approval. You only have exclusive patent rights in the region where you filed your patent. You have no protection in your country, in other countries that you have not registered your invention. Therefore, you must file an application in every area you want exclusive rights. If someone infringes your patent, you must be willing to defend it as well. Not only can this be costly, but it can also be time-consuming to monitor, track down, and bring down any wrongdoers to justice for infringement. And once the patent is expired, which is between 14 to 20 years, anyone can use your invention or you can apply to have the patent reissued. Ethical argument. One of the main ethical issues we are having within intellectual property laws is that people are creating patents based on ideas, and though those ideas are great, are never executed. Based on my opinion, I think it's important to reestablish a new law that if the idea is not executed within a period of time, then the patent needs to be released to the public domain so that maybe another person can execute it. At the same time, the person who originally came up with the idea should be compensated at a very small amount for the contribution of the patent. This will eventually eliminate patent trolling, and at the same time, it should be fair on both parties. Global issues. One global issue that intellectual property law faces is the fact that many countries have different protection laws. Also, some countries have more stricter laws than others. It will be great if intellectual property could be supported by a universal law, which every country will adopt in order to fight unfair use of intellectual property. Intellectual property have its pros and cons. However, it's important for our economy to upgrade many of these laws because of the restriction of intellectual property is preventing new inventors from exploring new horizons because of the fear of being sued.